title. As someone here says here, tenants in common, joint tenancy, life tenancy. But for me, once you can establish interest in property and represent that interest in a bona fide way by virtue of legal, you have a strong leader, and we'll always say local stand. You have a position upon which to stand. There is some sort of document that supports your bona fide interest. That can be considered title. And of course, you have different types of title. So you have strong titles and weaker titles. We consider gift, a gift, a title of gift as a weaker title compared to a title of conveyance because there's no consideration passed, etc. But title refers to having that interest, because sometimes it's not only ownership. When we're talking about land, sometimes your interest is there and your ownership has not yet been illustrated. Happens a lot with inheriting land. So going back to that definition, I'm using the word interest because in property law, interest is very important and crucial. And people have rights in equity due to the interest that they may hold in land, right? And as we're talking about titles, sometimes when people do title searches is when the bacchanal start. All right? Because they realize that who they thought had title do not, and who wants title now needs to be decided. Correct? So I'm seeing the questions. We're going to come to them. Seeing the hands. I don't want to lose this point. But we're talking about, so we did a title search. We want to find out what is the story of this land. Who has interest in it? How has it been passed on? We come to a problem in the title, Risha. Let's say that we realize that two people really still have interest in this land and it has never been probated, and one of them entered into the sales agreement. How can mediation come in for that?
Ooh, interesting. So there was no title to the land, you said? And
yeah,
there
there's
was a
title. So Granny had her deed. Granny had her deed, but Granny left no will, because Granny say, if I write a will, I will die faster.
Right.
And so John and Ramdeen are cousins. John and Ramdeen fathers all died, and John and Ramdeen have two different fathers, and they are the last living relatives to Granny. Ramdeen went and put the land up for sale on Facebook. Listen, we're being real about what has happened, right? He put the land
Yes,
up.
because this happens.
Yes, put the land up for sale on Facebook. But Ramdeen knows he's still trying to get out of administration without considering John. Ramdeen enters into a sales agreement with Judith. Judith feels she have good land. The title reveals that Ramdeen has never gotten a grant or anything. But John won the money because the land is 1.5 million. And right now, John don't mind.
Getting 1.5 million.
Yeah, or half, But can
Right.
Ramdeen do the sale without John? And how may mediation come in there?
I believe so. This is always a tricky topic within mediation because it really is on the side of the law and it really will depend on every individual case. But given the scenario that you mentioned, mediation can come into play where you guys try to find a way out of the sales agreement, I would say. But that's just my opinion on it. It's really up to what the parties would like to do. Because at some point, you have to go with what the law says, which is proper title must be achieved in the first place. So you wouldn't be able to sell the land without going the proper procedure and the proper process.
Yes. You need to clean up the title, but you can't have a mediation before and agree with your parties who are interested in what they would like to do in the event that things clean up. All right? That can't happen.
Correct.
I want to go quickly across to the questions that are seeing people's hand. Helen Bernard, your hand is up. Rhonda, your hand is up. If you guys' hands are up, please just write your question. We can't allow you to speak when you put your hands up. So please write your question. In the meantime, I'm going to answer some of the written questions here. Hi, good evening. This is from Listra Foster. She said, if a grandchild grew up on property shared by siblings and his mother died, does he have interest in the property? The grandparents did not leave a will. Beautiful question. So grandchild grew up on the property shared by siblings and his mother died. So the answer to that question will be, who has proper title? Is it the grandparents? And how is the title held? After we have established that, who is still alive and in accordance to the Succession Act entitled to apply for letters of administration for the grandparents? Because the grandparents' title cannot be transferred until there's a grant for their estate. Only after that could he now, as a grandchild, understand his interest, if any, in there. That there needs to be an administration, Lisa, of the estate of the grandparents. Because perhaps grandpa died, and when grandpa died, because there was a joint tenancy, left it for granny alone, and granny was the last owner, but you have to probate granny estate, and then you have granny's children. His mother may have died, but he may have aunts and uncles that in the succession line supersedes his interest to apply. So all those things will have to be considered, all right, before we reach down to the grandchild. Of course, as well, these things can be helped with mediation as well. When you come for the law part and we understand who has to inherit what, you mediate. Could there be an adverse possession claim on freehold land? Yes, Carol, but there are rules that govern it. If the freehold land is private, there's a certain amount of years that needs to be passed of undisturbed access and occupation of the land. And if it is state land, there's a different amount of years. Somebody asked, what about tenants in common? And we would have spoken about that. If you are tenants in common and you have a deed or a title document that illustrates that, you are still considered having title. Burke answered, John and Ramdeen need to bring the title under the RPO. Not necessarily Burke, right? Not necessarily. They may be able to probate it downward, but they need to come to an understanding first about how they would like to represent. And as Risha would have said, the sales
That's where the
agreement,
mediation comes in.
yes. And one time understand the sales agreement is void. If you are in agreement with somebody who represents themselves as something that they are not, it is not binding. So for instance, if I enter into agreement and I say I am the owner of, but I am found not to be, the other party is not going to necessarily be bound by that agreement. That is why you are referred to as something in specific. Something specifically when you have a contract, right? There's a reference to you as a party. Herein referred to as, and these little things, I can't wait for us to reach contract law and mediation, because that's a different ball game.
That's a different ball game.